have the right estate planning strategy, the legacy plan for you and your family? Are you someone who's been avoiding setting up your estate plan because you just find it confusing and there's just so many avenues that you can go down and you don't know which one's best? Or are you concerned that you're not going to leave the assets or the money that you have behind to the right organizations or people that you want to, or you're not going to be able to do that in the most tax efficient manner? If that's you and you have those questions, then boy, do we have a great interview for you lined up today. I have with me Daniel Perry from Wooden Lamping. So Daniel, I'm so glad that you're here.
Thanks for having me. I'm happy to be here.
And then just as a way of introduction, I'm going to just go ahead and read Daniel's bio, and then I'm going to call you from Dan. I'm going to call you Dan from now on.
Great,
because I
thank you.
asked you at the beginning, I was like, hey, do you prefer Daniel or Dan?
Yes.
So Dan's fine. But as way of introduction, I'm going to read your bio, and then we're going to jump off into just basically 10 kind of basic estate planning questions that we think that everybody really should know the answer to moving forward, or at least ones that we think would be beneficial, really specifically around those, like our target audience are those that are really nearing retirement or who are in retirement. So a lot of those questions will be, in relation to those types of people. So, but Daniel Perry is a highly experienced attorney specializing in estate planning, tax, and business law. He's licensed to practice in Ohio, Kentucky, Indiana, and Tennessee. His estate planning experience includes handling matters related to representing executors, trustees, beneficiaries, and clients in probate and estate administration matters, including trust administration, preparing estate tax returns and decedent income tax returns. Additionally, Daniel has provided counsel on complex corporate taxation issues, private equity transactions, and a range of strategies for Medicaid planning to maximize the protection of non-exempt assets. For his business law clients, he's counseled them on corporate transactions such as mergers and acquisitions, joint venture, formation, stock offerings, limited partnerships, and notes. And Daniel graduated from the University of Dayton School of Law. He lives in Northern Kentucky with his wife, Catherine, their 3 children, and the family dog.
That's right.
Yeah. So again, thanks for being here. And just
Absolutely.
Again, as way as introduction, my name is Spencer Ford. I'm CEO and Wealth Advisor with Conservative Financial Solutions, and we're excited to get into this interview as part of the Money Minute. So we're getting ready to go through the largest transfer of wealth in our nation's history, trillions upon trillions of dollars. And so we all know that that's barreling towards us. And so the first question that I have for you is, from your experience, what are some of the most common estate planning mistakes you see families make in real life? And are there any kind of stories that you might be able to share of some of the things that you've experienced?
Sure. So I think one of the biggest mistakes that I see is the set it and forget it estate plan, whether it's a will or a trust. One of the things that I see when a client comes into my office for an estate administration is I've got a 25, 30-year-old will. And then we start digging through things. Yeah, all the children were named, but they were minors.
Yeah.
It looks like everything's going to be just fine. Everything's going to go to the 3 children that are now grown adults at this point. But then I start looking through the beneficiary designations, and I see, who's this Jane Doe here? You're not married to, your dad wasn't married to Jane Doe. Oh, that was my mom. And now we've got an old beneficiary listed on a life insurance policy. Some of the biggest mistakes that I see are we have an estate plan that is not working in conjunction with your non-probate assets, such as life insurance, IRAs, retirement benefits. So estate planning can't be a one-stop thing. You really should be reviewing things every 3 to 5 years.
Yeah. Oh, actually, one of the things that we encourage families, especially around powers of attorney, is I tell them, hey, you should be reinstating your power of attorney every 3 to 5 years.
Yes.
I'm kind of interested to get your take on that, because I tell them, I was like, if you walk into a financial institution with a 15-year-old power of attorney, it still might be the power of attorney that you want on file. But I said, no financial institution is going to accept that, because they're going to look at this and say, yeah, this is what you wanted 15 years ago, but how do we know that this is the way that you want it now? So I said, you don't have to redo the whole document, but you need to just have a reinstatement letter that says, I looked at this, sign it, get it notarized, attach it to the back of it. That way, if you show up with that 15-year-old power of attorney, but there's these reinstatement letters every 3 to 5 years, then the financial institution is going to look at that and say, oh, okay, clearly this person's looking at this. This is the way they want it. Do you think that that's good advice?
It is, because I deal with powers of attorney all the time, and there's 2 types of powers of attorney. There's a durable that takes effect immediately, such as Spencer, I want you to handle my financial affairs, and I want you to have that immediately, which means you can go to the bank and pay for bills on my behalf.
Yeah.
Or there could be a springing power of attorney, which means it only comes into effect if I would become disabled, for example. But I can't tell you how many times I've dealt with a financial institution where it's a 10-year-old power of attorney, and they've said to me, well, we have no assurance that this is still valid or if this is what the person wants. I went into a bank here locally with my wife's power of attorney. And they said, who wrote this? This is too old. And I said, well, I wrote it. So it does happen.
Yeah.
And so I say, either reinstate the power of attorney or have an instruction letter along with it that's with a correct date that just says, look, this power of attorney is still valid. Here's my attorney's information. Is going to go a long way with the legal department at those banks.
Okay, good. Yeah, we always encourage families to be looking at their legal documents, and then especially around those power of attorneys, reinstating them. So glad to know that's the right move there. Mm-hmm. So second question, many families believe their will or trust controls everything. So can you explain how beneficiary designations can override estate documents and where families get tripped up?
So this is one of my favorite questions. Your will controls your probate assets, period. That's it. That would be things such as your house, if your house is titled in your name, your tangible personal property, things in the house, your car that's titled to you. That's what your will is going to control. Your life insurance, your IRAs, retirement accounts, anything with a beneficiary designated, that's going to operate outside of your will or your trust. It's going to go to that direct beneficiary listed on those accounts. Your will's not going to control anything with that. And that's where I see things that can get messed up, such as, a parent may leave, an IRA to one child, and then they have their will going equal to these 3 children. Unfortunately, those 3 other children, they don't have any legal recourse. Mm-hmm. These assets pass outside of your will, pass out of your trust.
Yeah, it's going to go based upon the beneficiary designation.
Exactly.
Yeah.
It's only going to control what's called your probate assets.
Gotcha. As a follow-up to that, we will talk to families about putting a TOD designation on their home. So I know that that's good for Ohio and Indiana. You can add a TOD designation on your home. So you can add a beneficiary designation on your home.
Yes.
Won't pass through probate. What's nice about that is for many of the families that we serve, their largest asset are their retirement accounts, and then their second largest asset is their home. So you can basically have beneficiary designations on your largest assets, which is your retirement accounts, and then your home as well. But the state of Kentucky is different with that. In the state of Kentucky, you can't add a TOD designation on your home. So I know a lot of families that we serve in the Kentucky area, they'll actually use a trust to accomplish that goal. Can you talk a little bit about that?
Sure. So Ohio and Indiana, you can have a TOD designation on real estate, transfers directly to that surviving person upon death. Unfortunately, in Kentucky, they have not passed that statute here. And so a home is going to be what's called those probate assets. Mm-hmm. And I took a client through this recently and say, well, we want our house to go to our 3 children, and we want to put that in the will. And I said, well, when you both pass away, your son or daughter is going to have to go to probate, file an application to petition the probate, petition the will. It's going to take some time to get authority just to sell that house. We can get around that by titling your home in a trust. And so the difference between a trust and a will in that sense is, instead of going through that time delay of going through probate, waiting for authority, hiring the realtor, going through all those steps to be able to sell that house, well, now your successor trustee, son or daughter, takes over immediately upon your passing. They can go through the process quickly of selling the home. Gotcha. So here in Kentucky, for real estate, using a trust for what we call probate avoidance can be a very good decision.
Okay, perfect. So third question here. Most people think that estate planning is about what happens when they die, all right? How important is planning for incapacity, and what documents are absolutely critical for that?
So another great question, and I learned about this when I was 30. I'm 43 now.
Okay.
When my financial advisor said, Dan, you are much more likely to get disabled than die. That's why the life insurance we got you is so cheap. And it's true. And so when it comes to estate planning, it's not just planning for what happens when you pass away. It's also planning for your incapacity. You're much more likely to suffer a disability as opposed to, dying unexpectedly. And so there are really three things that, we implement and we recommend. One is a durable power of attorney for financial matters.
Yeah.
Make those financial decisions should you become incapacitated. Another would be a living will, which states your final decisions when it comes to withdrawing life support and life-sustaining treatment. And the third is a healthcare power of attorney or advanced healthcare directive, designated a person of your choosing to make your healthcare decisions should something happen to you. Mm-hmm. Without those documents in place, if you were to have an event where you're incapacitated, your loved ones, not even your spouse, is going to be able to make those financial and healthcare decisions for you. They're going to have to go to court.
Yeah.
You're going to have to go to probate, institute a guardianship, go through that whole process, and then a court's going to give them guardianship, and then finally they can make those decisions. We all remember that case from, it's got to be 25, 30 years ago now, of Terri Schiavo that was down in Florida. That was a perfect example where she was essentially brain dead, but sitting in a hospital bed for more than a year.
Yeah.
Because no one had authority to make those decisions for her.
Yeah.
And so those are three important documents. A trust can also be used for incapacity planning. That's another aspect. So instead of, if you have assets titled to a trust and you have a successor trustee, a lot of the ways that trusts are drafted is that not only in the event of death, but in the event of incapacity, the successor trustee can take over.
Yeah.
So instead of going to court, going through a guardianship, going through all that stuff, they immediately have access to those trust accounts and can pay those bills, for example. So incapacity planning is a very big part of the estate planning discussion. Another
thing that I've often encouraged families to have as part of those documents is a HIPAA waiver attached to it too. I don't know if that comes standard or not, but I always ask them to have that in there too, because whenever you go to the doctor, you sign a HIPAA waiver, a medical release, to give these people have permission to, be privy to my medical information. Obviously, if you're incapacitated, you can't sign one of those. So I always say, hey, make sure you have that. So that as far as you're concerned with the estate planning documents that you do, that comes standard. You're going to include that in there.
Absolutely.
Okay, great. Fourth question, and kind of getting more to as it's related to retirement accounts here. So, how has the Secure Act, so passed in 2019, and this advent of the 10-year rule, so this 10-year inherited IRA rule how has this changed the way attorneys and financial advisors should coordinate estate plans? Let me just read it again from the beginning so it's not all jumbled up. So, how has the Secure Act and the 10-year inherited IRA rule changed the way attorneys and financial advisors should coordinate estate plans? So the Secure Act was by far one of the biggest changes that we've seen when it comes to retirement accounts and estate planning in the last 25 years. Prior to the Secure Act, there was recommendation all the time. We did it as well, that you have your beneficiary listed as your spouse. No matter what happens, if you pass away, as you know, spouse can withdraw that, balance out that inherited IRA over their lifetime. And then everything passes on to the kids because that was the law at the time. The kids could then withdraw it out over their lifetime. Yeah. It's no longer the case in a post-Secure Act world. Now a non-spouse beneficiary has to withdraw out that balance inside of 10 years. And so what that's really kind of happened now is we've got the children that are going to could inherit a large asset that now they're going to have to withdraw out over 10 years at their income tax rates. And remember, all the money that they take out, it's taxable income to them. And so what's becoming more and more prevalent now is, discussing Roth conversions with clients. Yeah, absolutely. We do that a ton. And I tell that to a client, I told that to a client recently. You have $500,000 in this IRA and you are 75. The chance of you spending that down for both of you is very limited. I would go speak with a financial advisor to talk about a Roth conversion, so that you're not leaving that mess for your children. And what I found is in a post-Secure Act world, these retirement accounts, it's almost a slow problem that's just gonna get bigger. Yeah. And so we talk a lot about, let's get a financial advisor involved. If you don't have one, we need to talk about a Roth conversion so your children aren't hit with that
really big tax event that they're going to have.
Yeah, the example I like to give is like, let's say you have a child and they inherit a $500,000 pre-tax IRA. If they're going to have that thing depleted within 10 years, they're going to have to take out $50,000 a year plus interest to get that thing depleted within 10 years. Could that bump them into a higher tax bracket? You know, it depends on their situation, but absolutely it could. And I also tell families to add insult to injury. Most of these children, or not most, but many, you know, I don't want to say most, you know, for compliance reasons, but many families, many families will inherit these funds during their peak earnings years.
Yes.
In their 50s and 60s. So they're earning more money than they've ever earned before, and now they have to take this big distribution on top of it. Could that bump them into a higher tax bracket? And absolutely it could. So I'm so glad you bring up this idea of Roth conversions.
Yes.
Now, one question that we get a lot of times, or that families have questions about, is leaving IRA money to a trust. And that's always been a little point that always, my ears perk up when I see families that are going to leave IRA money to a trust, just because of kind of how careful they need to be if they're going to do that in order to make sure that that child can still take advantage of that 10-year rule.
Yes.
So can you just provide some insight around it? Because I've been a part of some horror stories where this IRA money was left to a trust and it all gets paid out in 1 year. Or at best, it gets paid out over 5 years, or subject to the 5-year rule as opposed to the 10-year rule. So it's my understanding that you can leave IRA money to the trust and they can still take advantage of the 10-year rule, but needs to be structured in a very specific way. Can you just elaborate on that a little bit?
Yeah, so I have lots of clients that will leave IRAs as a contingent beneficiary to their trust after their spouse. But you have to be very careful with what's called the conduit trust rules. And that's a certain provision under the code which says if you have the specific required language that makes it a conduit trust, means that what the IRS will do is that they will see through the trust to the individual beneficiaries. And so instead of it being paid out over 5 years, it's paid out over that 10 years for a non-spouse beneficiary. What also that some families will do will not only do a conduit trust, but an accumulation trust. In a post-Secure Act world, we don't see that as much. That's mainly for, I've left a large IRA to my children. It's protected inside of this trust. I've been very careful to make sure that they get the 10-year rule, but maybe it's a beneficiary that's had some money problems, or they've been through a divorce. And so an accumulation trust allows that amount that comes out and has to come out within 10 years being forced into a new investment in vehicle inside of the trust, and would just accumulate there and provide an income source to that beneficiary.
Yeah.
So there are ways to do it, but you do have to be very careful, because I've seen situations where I was administering a trust and they had to pull $175,000 out all at once. So you do have to be very careful with how those are structured.
Yeah, perfect. Do you, let's say you have 3 children, do you need a conduit trust for each separate child, or can you still have it? Okay, so you can still structure it all within the same trust. You just need the right language.
That's correct.
Okay, perfect. We see many families with trusts that were created years ago. You kind of maybe touched on this a little bit already. So when does a trust still work well, and when does it actually create tax administrative problems today?
So I spend a lot of time talking about this with clients. It's when I'm looking at trusts, especially trusts that have been done, 5-10 years ago. We had a new tax bill that was passed that took effect in 2026, which raised the estate tax exemption to $15 million per person. For a married couple, $30 million you can exempt from federal estate tax. And prior to that, it was still very high, about $13.92 million per person. About 10-15 years ago, it was a lot lower. And so when I see a trust from 10-15 years ago, it's very common to see what's called credit shelter family trust provisions, or what's called an AB trust provision.
Yeah.
And the purpose of that was to make sure that assets get, that federal exemption got maximized. Now, most people don't have $30 million, but they have these beautiful credit shelter trust provisions that are just going to be going unused. And so, unfortunately, what can actually happen with those credit shelter trust provisions is that you can have an asset that's going to all the assets kind of being locked in this AB trust, And now you've blown the step up in cost basis too. And so, when I'm looking for tax planning with trusts, I'm looking at, okay, is this person have $30 million in wealth, or do they anticipate? Maybe they've got a highly appreciating business. We need to talk about that. If they don't, then, okay, let's look at this from another perspective. What do you want to accomplish? Well, I want things to be simple for Susie and Johnny. I don't want them to go to probate court.
Yeah.
Okay, great. We don't need to talk about tax planning, but let me show you how a trust can avoid probate and that issue for your son or daughter. And so trust can make sense from a probate avoidance perspective, but the tax perspective is just not a big of a deal anymore. And sometimes those credit shelter provisions for a non-taxable state can make it administratively burdensome to administer, and it can cause some unfortunate tax consequences as well.
Okay, that makes sense. That makes sense. Families often default to equal inheritance, but sometimes equal isn't fair.
Yeah.
So how do you guide families through those sensitive conversations?
So I have these conversations every day, and I say, equal is not always equitable. And one example that I see all the time is, a person's passing away and they own a business. And Johnny worked in the business. He worked in it his whole life, and now it's time for his dad to retire, or if his dad passes away, and for Johnny to take over that business. And the two other children live out of town, and they have their own careers. They have their own great careers, but they don't want any part of the business. So is it fair to Johnny to divide the business 3 ways, and now Johnny has to buy out his siblings at the fair market value of what that business is worth on that when dear old dad passes away? Especially if there's no life insurance, how's Johnny going to do that? So sometimes it's not equitable. It's to do equal to the 3 children with a business owner. Another example that I see all the time is, well, we help Susie out quite a bit.
Okay, yeah.
Susie doesn't make a lot of money, so we helped her with a down payment on her house. We've helped her a lot over the years. But, James, my son, he's been doing great. We've never had to help him out. Does it make sense for it to be divided equally in that sense? So I help clients guide through that conversation. And a lot of times clients will say, well, I think I already gave her inheritance, so let's make it a little less equal here. And so it's an important conversation to have, and it's one I'm very comfortable having with clients and guiding them to that right decision, really what's most important to them.
Yeah, it's funny you bring up the family business. I'm part of a family business. My father created this company.
Okay.
My brother Austin and I are in it, and my father's actually still working as well, but there's 5 of us total. I have an older sister and older brother, and then actually my brother Austin, who's in the business with me, he has a twin.
Oh, wow.
But Austin and I are in it, but we have 3 siblings outside of it.
Yeah.
So, those topics do come up as just part of conversation and everything. From your experience, what happens when heirs inherit significant assets but haven't been included in planning conversations beforehand?
I think it reminds me of a slow-moving rock heading down a hill, just waiting for the worst thing to happen. Because you have children that maybe they inherited a retirement account, and they don't know what the rules are, and they say, well, okay, I'm going to take out the $200,000, and they just got hit with a big tax bill.
We've had people come to us after the fact.
Yes.
Yeah.
Or, or you got a child that inherits a piece of real estate. I've had this case where a child inherited a piece of real estate in Idaho. He's never been to Idaho.
Yeah,
he doesn't want to live there.
Don't know state laws
And so it's, I have no use for that. So do they sell it? And so I'm very intent with families. You need to schedule what's called a family meeting and tell them, these are the decisions that we've made. I'm not talking about going down to the dollar and down to the penny of all the assets you own, but say, here are the decisions we've made. Here are where some of our assets are. Here's who's going to be in charge. Here's why we've decided this. And a lot of times when you have those conversations as a family in advance, you avoid hurt feelings, you avoid litigation, unfortunately, because the children know, oh, this is why mom and dad did it this way. That makes sense to me.
Yeah. Okay. So just getting ahead of it. Is there a specific age group where you give that advice more to not, like, someone in their 60s, they kind of tend to think that there's still a decent amount of life ahead of them. Are you more so encouraging families to do that, like just immediately get it out of the way in their 60s? Do you more encourage families in their 70s or 80s to do that? I was just curious if there's any if your advice changed based upon, what decade of life they're in.
It's generally early on in their 60s.
Okay.
I'm having these conversations because I've also seen it where they're trying to do this in their 80s and someone's getting very close, has a health event and is getting close to death. That's the worst time to be having that conversation.
And tomorrow's not promised today and all those things.
So I say have those conversations early and say, this is what we've decided. It may change, but this is the reason we decided to do it this way.
Gotcha. Where do you see estate plans break down most often in blended family situations?
So blended families are different. And the biggest horror story that I hear is what I call accidental disinheritance. And so think of, you got John and Jane Doe, and they got married, had 3 children together. John passes away. Sorry, statistically, the men pass away first. Jane gets remarried later in life. Jane and she's thinking, I want to take care of my spouse. And so she leaves her assets to her new spouse to use during his lifetime. Jane passes away, new spouse changes everything, leaving everything to his children from his first marriage. Well, now John and Jane's children didn't receive the inheritance that they thought they were going to receive. And so I see that a lot, and there's usually no legal recourse for those children. You had an estate plan, leaving everything, John leaving everything to Jane. Jane takes the money. Jane, years down the road, gets remarried, leaves everything to new spouse. Jane passes away, new spouse leaves everything to his children. It happens a lot more frequently than you think. And so in those situations, it's important to have that candid conversation. And a lot of times I recommend what's called a QTIP trust, Qualified Terminable Interest Property Trust. And what that essentially does is it says, I am leaving all this property for my spouse to enjoy during their lifetime. Upon my spouse's passing, this trust property goes to my children. And so you do have to address the elephant in the room when you have that conversation. Okay, what is your goal here? Do you want to give everything to your new spouse? Or do you not care about that? Or is it you just want to leave some to your new spouse, but you ultimately want everything to go back to your children? And that's really where a QTIP trust can make sense. But that's a way that you can serve both roles, provide for your new spouse during their lifetime, but also make sure that the principal and all the wealth that you accumulated with that other parent goes back to your children upon their passing.
Yeah, and like just kind of going back to the probate conversation, probate is contestable, right? So it's public record. Anybody can hire an attorney and contest what's written in a will or anything of that nature. It's not that they would win the legal battle, but there's nothing to prevent somebody saying, well, so-and-so told me on their deathbed that they actually wanted me to have this. And like, again, it might not go anywhere because there's not like any legal basis for it, but there's nothing to be said. It's still going to run up the probate bill. Right. And so oftentimes, a trust can be an avenue to avoid those types of sticky situations, whether it be, not even if it's a blended family especially is a great example, but families are messy. Like who doesn't have a family that's messy?
Sure.
Right. And so if there's some tension between siblings, a brother and a sister, brother, sister and sister, whatever it may be, right? And those tensions exist. Could be a really great reason for a trust. Just to make that transition as clean and transparent and as easy as possible.
Absolutely.
So a lot of times we'll just talk about families like, hey, if for a lot of families, if there's not like this big brewing tension, if there's not a blended family situation, there may not actually be any reason for a trust. Probate might be perfectly fine and reasonable, but there are a lot of reasons to have a trust. What I like to tell families is a trust is just a means to an end. So if you can get to the end you're looking to get to without the trust, no big deal. I'm not
Yes.
trying to push a trust on you.
Yeah.
But a lot of times you do need that trust to get to the end that you're looking to get to, or you might not need the trust to get to that end, but that trust provides just a little bit more stability, a little bit more assurance that that end that you're looking to get to will actually take place.
Yes.
And I also tell families what's nice about a trust too is it gives you more control from the grave.
It does.
So
Yeah,
you have that benefit too.
I mean, what I tell people too is, especially in a blended family situation, you know, probate's going to last 8 to 12 months. If someone contests, add another 12 to 24 months on top of that.
Yeah.
Because it has to go through the court system there of some person challenging the will, even if it's completely illegitimate. Add another 12 to 24 months to that probate administration. Also, another thing when you're in a blended family situation and you're worried that someone's going to contest, other than making everything as crystal clear as you can with your estate planning instruments, is to consider a no contest provision, which is a provision that says if anybody challenges this, any beneficiary challenges this, they receive nothing under my estate. And so if you know that someone who's being treated less than equally, well, that may disincentivize them to challenge that will or that trust.
How is, this is a fun one. How is estate planning changing with digital assets like online accounts, crypto, and password access?
So this is an area where the law has not caught up with technology.
Yeah, very much so.
We're
dealing
it.
with the same thing in the financial industry. Yeah.
I mean, we're seeing it all the time. Cryptocurrency is a perfect example. When you're transferring cryptocurrency upon passing, it's not just who gets what, it's where is it. You need to have the secure wallet, and you need to have the key to that wallet in order to access it. And so that's part of the planning conversation. And it's something that I have is if you do have any digital assets, including cryptocurrency. I used to not ask that question, but I can't tell you how many times someone has said yes now.
Yeah.
And I would not have asked that question
you have
5
to
years
ask
ago.
it, yeah.
But even beyond cryptocurrency, there are things such as online accounts. You know, some people have, you know, blogs out there. You know, that's an asset. Or, you know, their online banking accounts, Gmail, social media accounts.
Yeah.
Under a power of attorney, you need to have specific language in there. You're not going to be able to access it. And I always tell people, you know, with your estate planning, especially when it comes to digital assets, make sure that you tell, you know, your executor or trustee, here's a list of all my accounts. These are the passwords. I can't tell you how many times I've had to go through an estate and we are still finding assets when we're almost to the end.
Yeah.
And so, you know, cryptocurrency, digital assets, you know, you need to be aware of where all this stuff is. You know, does the person own any type of cryptocurrency? How is it accessed? Who gets it? Who's got the key? I heard a story not that long ago where an individual owned cryptocurrency and he thinks the hard drive that holds it is in a landfill. Well, he's never going to get that back.
Yeah, no.
He's got no way to access it. It's decentralized currency. And so this is really where I see a lot at continuing legal education events is, okay, how do we structure trusts, wills, and powers of attorney now to account for digital assets? It's going to be a moving area of law, but we're as estate planners, we're starting to get a handle on it a little bit easier.
Yeah, you think of like a YouTube channel, right?
Yeah.
I mean, that's reoccurring revenue. And even if like you pass away, just as an example, even if you pass away, there's still people viewing those YouTube channels. There's still ad dollars being generated from that YouTube channel. Like, so I guess maybe it kind of becomes like a royalty situation at that point in time. You know, I don't know where it would fall under, but it seems like it would fall under like royalties, you know, as like an estate planning type of situation. So
yeah, there's constant royalties from music and television. I know that I haven't looked at it in a couple years, but Michael Jackson's estate is still generating income every year. It still files a tax return.
Absolutely, yeah.
And it will for many, many years to come. And so it's getting a handle and having a handle on all of those types of assets. Cryptocurrency, not just your financial accounts, not just your house, not just your cars, but cryptocurrency, assets that generate income. It's important to understand all of that when you're having that planning conversation.
All right, last question, and we might even just continue the conversation a little bit, but last question I had on here, okay? So number 10, When financial advisors and estate attorneys work well together, what does that collaboration actually look like from your perspective?
So in my perspective, estate planning attorneys and financial advisors work best in a collaborative environment. I've seen countless times where attorneys and financial advisors are working in their own silos. The attorney is doing, you've got $2 million in assets, you need a trust, I'm going to put you in this trust. Yeah, you need to change these beneficiary designations, make sure you talk to your advisor about that. But no one's talking to each other.
Yeah.
For example, if I've done an estate plan for a client, it would be nice to know if a financial advisor was speaking with that same client a few years later who has a massive liquidity event, sold a business, came into a lot of money. Oh, well, now their net worth has ballooned. Maybe we need to talk about charitable planning. So in my experience, estate planning and attorneys and financial advisors work best together when we're in the same room. What you might be thinking for an investment perspective would have bearing on maybe what I'm going to recommend to that client from an estate planning perspective.
Yeah.
And so I find that better meetings take place when we're both in the same room, or at least we know who each other are, can pick up the phone and have a conversation. Hey, I'm representing one of your clients. They came in talking about this IRA that they have, and they want to leave it directly to their children. I said, I wouldn't recommend that, and maybe the financial advisor would say, yeah, I don't know why they would have recommended that either. So, because, it needs to go to the spouse or any number of reasons. So my best conversations with financial advisors and clients is when we're in the same room, or we know who each other are.
And that's what's nice about the relationship that our advisors have with you and other attorneys, with Wood and Lamping and stuff, the law firm that we're most closely associated with and so forth. And like we've seen it all the time. We've seen where people come in with a trust and we're like, okay, well, how's this trust being funded? There's this trust that exists, but there's no contingent beneficiary that has the trust listed. There's no assets currently in the trust. It's just, okay, it exists, but it's kind of just this hollow shell, and
Exactly.
what's going to happen here. Or we didn't touch on it today, future conversation, actually have a conversation set up with Jennifer to talk more about Medicaid spend down. But, we have to work really closely with the attorneys when it comes to a Medicaid spend down situation. A lot of times, we get that spend down letter, and then we work with the attorney to help decide, okay, well, which assets are we going to spend down first from a tax planning perspective, because there's different tax statuses of different accounts and stuff like that. So, I don't want to speak out of turn or anything like that, but I just don't see how you can have the most efficient estate tax legacy plan that you could possibly have if your financial advisor and attorney aren't communicating back and forth with one another.
Yeah, you can't, because, estate planning, again, it can't be the set it and forget it that I talked about earlier. Once we have the legal instruments in place that have been signed, we need to look at beneficiary designations. Hey, did you do this? Remember I told you to change the contingent beneficiary from your one son to now your 3 children? Did you take care of that?
Yeah.
Because this estate plan is not going to work unless you do it that way. And I find that it's just a lot easier dealing with your company. When we're working on the same matter together, is that I find things just go a lot more smoothly.
Anything just that you would like to add in closing that is just top of mind for you? That's maybe not something I addressed or a question I asked or anything like that.
Just when you are amending an estate plan, maybe you have a trust and you're amending that trust, it's always a good idea to look at those beneficiary designations. I know I've talked with clients during this isn't their first time doing this, and I said, well, you want to make sure that those beneficiaries say that, and they said, oh, we did that years ago. I was like, well, we're already doing this. Well, it's a good time to go check. And they come back and say, you're right, I didn't have any contingent beneficiaries. I said,
every single time we sit down with a family to do a review of their accounts, we call it our strategy and tactical visits, every single time we review the beneficiaries with them on every single account.
Yeah.
Every single time. and it's just incredible. And it is sometimes, a lot of times, if there are changes, it's just really simple changes.
Yeah.
Maybe somebody got married and changed their last name. Maybe somebody had a child and now they're updated to per stirpes as opposed to per capita. Maybe they moved and it's just an address change. But just even these little things, if you do them while you're still alive, it just can. It's not that they wouldn't necessarily get the money, but it can just make the process for the beneficiary so much better.
Absolutely.
Yeah.
Yeah, and I'd say the last thing I would say is, if you have a trust, make sure it's funded.
Yeah.
I've administered so many trusts where we have to open a probate estate.
Yeah.
And it's,
We see it all the time. Yeah.
Why was that investment account have a beneficiary of the estate? Why did that IRA have a minor beneficiary as a whole number of things? And we're having to open up probate estates, guardianships. When the family comes in with this big leather-bound binder that obviously they paid a lot of money for, but nothing was funded into it.
Yeah, the attorney and the financial advisor weren't talking to each other.
Exactly.
Yeah.
And so it's important, if you do have a trust, make sure that it's funded. Make sure that you're doing what you're supposed to be doing to make sure that plan works well when that time comes. Because no plan is even worth the money that you paid for the paper that it's written on, unless it's going to work the way that you thought it was going to work when that time comes.
Well, great. I really appreciate you being here and taking the
thank you for having
time,
me.
and we really appreciate the relationship. And maybe we'll get to do it again sometime. We'll have part 2, and I'll come up with more crazy questions.
Great. I look forward to it.
All right. So we have Daniel Perry goes by Dan. I'm Spencer Ford, and we'll see you in the next one.